Kane Srikanta.
Madam Presiding Member, on behalf of my party, the Lankai Tamilarasa Katchi, I am happy to participate in this debate that is in progress. From the government ranks, there is a pious proclamation that this bill is being piloted with the noble purpose of upholding the rule of law. At the very outset, Madam Chair, I am rather constrained to state that this pious proclamation on the part of the government does not carry any conviction with us, given the fact that what is obtaining in this country is in fact an unfortunate situation wherein we find serious crimes including murder, rape, abduction, and robbery being committed all over the country, and more particularly in the war-torn Northeast. Before dealing with that aspect of the matter, I would like to make a few comments on behalf of my party in relation to this bill, and more particularly to certain provisions therein. Madam Chair, I find that there are certain strange provisions that are being repeatedly sought to be placed in this bill that had been in force 2 years since, that had been in force till May this year for a period of 2 years. It's very unfortunate. The government has slept over the matter without knowing the fact that the period of operation has lapsed at the end of May this year, and it has taken almost 20 months for the government to pilot this bill with retrospective effect so as to clothe with the legality all that has taken place under this act since the end of May this year, so that they would be legal in the eye of the law. Anyway, I have no quarrel over that, given the fact that the government is preoccupied with various other matters, and I do appreciate that. I do understand that. In relation to the provisions of this bill, there are 2 or 3 matters I think I am duty-bound, not only as a member of the opposition, but also as a member of the legal profession, which is supposed to be a noble profession in this country too, to submit for the consideration of this august assembly. I find, as in the case with the early act with the same caption, that the accused under this act is not given the right, or rather denied the right, to cross-examine any witness presented by the prosecution at the preliminary inquiry. Even the magistrate before whom the inquiry is to be held does not have the power to do so, does not have the power to give an opportunity to the accused or to his plead, as the case may be, to cross-examine the witness concerned, unless, of course, the prosecution agrees to place the witness concerned in the hands of the pleader, of the accused, or the accused, as the case may be, for cross-examination. At the same time, Madam Chair, I find that this particular provision has no extension of applicability in relation to the accused or a witness or the witnesses, as the case may be, who could be presented to give evidence on behalf of the accused in an inquiry of this nature. The bill is silent on this matter, strangely silent on this matter, while the bill is rather quite categorical in its assertion that no cross-examination of any witness for the prosecution is permissible, unless, of course, the prosecution is willing to place the witness concerned for cross-examination. The bill is rather very strangely silent, though it makes provision for the accused and also for any witness on his behalf to give evidence. So one has to presume that in the event of the accused choosing to give evidence on his own behalf, and also in the event of his leading evidence through his own witnesses, the accused and/or the witnesses, as the case may be, would be cross-examined by the prosecution. This goes against the very basis of justice, madam, because the law says, I don't think anyone would quarrel with me over that. Our constitution says, furthermore, that everyone is equal before the law, every citizen is equal before the law, and is entitled to equal protection of the law. While thinking of the purpose of this bill as sought to be presented by the government, in that there have been repeated assertions by very many eminent members of the government, some of whom are also members of my own profession, in that it is being brought in for the purpose of a speedy investigation and also for a speedy inquiry at the magisterial level, so that there would be a speedy process in relation to criminal offences, rather major and serious and grave criminal offences, so that the culprits concerned could be brought to book without any undue delay. I find, madam, that some of the provisions need a rethinking. A rethinking in that instead of clothing the prosecution with the authority to submit or not to submit its own witness for cross-examination by the accused or his pleader, I think discretion should be given, if at all, justice to be maintained for the magistrate concerned to decide on the whole question of whether a witness for the prosecution should be submitted for the cross-examination on behalf of the accused. And also at the same time, I think a rethinking is needed. A reformulation is needed in relation to the process of, or in relation to the provision of the accused being given an opportunity to testify on his own behalf, and also in exercising his own right to lead evidence on his own behalf. In that there is a danger. There is a great danger in that while the prosecution can withhold its own witnesses from being cross-examined on behalf of the accused, it can always cross-examine not only the witness for the defense, but also the accused himself or herself, as the case may be, in the event of the accused choosing to lead evidence through his own or her witnesses, and also choosing to depose on his own behalf. This is a matter I believe and I do hope would attract the attention of this August Assembly, so that the necessary amendments could be made. Madam, I find, though we have had this for the last 2 years, I find the police statements that are generally recorded throughout the country in the singular language, given the fact that the police department lacks the necessary personnel who are competent in the other language, the other national language, or rather the other official language of this country, namely the Tamil language, my own language, so that in the event of a person making a statement in Tamil, it could be recorded in Tamil. We find all the statements in regard to investigation generally and unavoidably in the singular language. And when one makes a statement in Tamil and when it is being recorded in singular, naturally and obviously and automatically and inevitably, there would be discrepancies. And when the statement is read out, and when it is being read out in the singular language, for instance, in a court of law either in the north or the east, now we are rather compelled to talk not about the northeast, but north or the east, I will come to that later at an appropriate time, then the witness concerned with the interpretation available in the Tamil language, and given the fact that we don't have adequate, competent interpreters to interpret something from singular to Tamil and Tamil to singular, not only in the northeast, but also in superior courts in the rest of the country, there would be practical difficulties. there would be practical difficulties. And given the fact that a police officer, given all his inabilities and shortcomings in relation to recording a statement in these circumstances, would be unavoidably making errors, what is the net outcome? The witness is given an opportunity to make alteration, additions, or amendments. In such a scenario, there are bound to be errors. There are bound to be discrepancies in the so-called deposition of the witness concerned. When the statement is read out, interpreted, and the witness given an opportunity to make alterations or additions or amendments, and to be called a deposition, recorded before the magistrate concerned, to be forwarded to the Honorable Attorney General for an indictment in this case before the High Court. What would be the net outcome at the trial in the High Court? This would necessarily have an impact on the outcome of the case. It would necessarily lead to a situation where the culprit concerned would be able to evade the process of law and would be able to get away easily. So I think the honourable members from the government ranks, I'm very happy that Honourable Andrew Bandaranaike is here. Though a non-lawyer, I think he is more competent than very many lawyers in this country in that. I think he too, if at all he would be addressing today, make his speech today, would be able to focus some attention on this. This is a serious matter. Given the purpose of the government piloting this bill today, this is a very serious matter. On the one hand, you are shutting out every opportunity for the accused to cross-examine. On the other hand, the bill is silent on this issue of cross-examination, the right to cross-examination of the prosecution of the accused or his witnesses. If one goes by the bill, I think the prosecution can insist before the magistrate concerned that it has a right to cross-examine either the accused or the witness or both in the event of the accused choosing to call evidence in addition to depose him before the magistrate concerned. This is a rather precarious situation, Madam Chair. I think I am duty-bound to place before this august assembly. Now, we find the government ranks repeatedly asserting that this is a must. This is a must in the interest of justice. This is a must in the interest of rule of law. But what is happening in this country, madam? What is happening in the Northeast? Has the government succeeded in arresting even one single person in regard to any one of the murders that had been perpetrated in the Northeast in relation to civilians? Since January 2006, I challenge the government to mention at least one name of one suspect arrested in relation to even one single case of murder perpetrated in the Northeast since January 2006. Government can't place it. Nobody can place it. Except for the arrest of certain suspects in relation to robberies perpetrated in the thick of night during curfew hours in Jaffna. That too, after the Honorable Chief Justice gave definite and strict instructions to the Inspector General of Police to have these culprits arrested, and in consequence of which 4 or 5 or 6 persons were arrested in Jaffna. And thanks to the efforts of the learned magistrate of Vaunia, there were arrests by police of certain persons involved in the cases of robberies perpetrated during curfew hours in Vaunia town a few months ago. There have not been one single case of arrest in relation to major crimes committed while the so-called war is in progress or has been in progress in the Northeast since 2006 January. This is the state of affairs. In Jaffna, madam, motorcycle-borne murderers are responsible for the continuing cases of murderous civilians in Jaffna Peninsula, including Jaffna Town. The victims include not only youths, but also elderly and even young women returning from their places of work. Obviously, these persons, these victims, are supposed to have had some links with the national resistance or rather the national renaissance on the part of the Tamil community. That is a different matter altogether. Or it may be that some of them might have been suspected to have had some links with the LTTE. If anyone has been suspected, arrest him or her, bring her to book, detain. We have no quarrel. Deal with the person concerned in accordance with the law. But what is happening? An open license is being given in the name of law, in the name of governance, by the powers that be, to armed groups that include elitist groups of the Sri Lankan army in the northeast. They are responsible. Karana group is responsible. I don't find Honorable Douglas Devananda here. His EPDP is responsible. Plot is responsible. A segment of the ENDL is responsible. And other paramilitary groups are responsible. And elitist groups of the armed forces are responsible. Not one single case of arrest, not one single case of investigation, not one single case of preliminary inquiry since 2006 January under the earlier law that has lapsed in May 2007, for which a new lease of life is sought to be given through this bill. With this state of affairs, I would like to ask every member of the government ranks who has the conscience is still active and alive, whether they can expect us, the members of the Tamil National Alliance, to place any faith in the so-called normal purpose that is being trotted out, that is being tossed about by the government ranks as the primary reason for the piloting of this bill. On the one hand, you say crime is on the increase. On the one hand, you say there are cases of abduction, there are cases of rape, there are cases of abduction for ransom, murders, so on and so forth. On the other hand, the government has given a free license for dirty, dastardly and cowardly, cruel and crude elements in the northeast. Some of whom don't know even their own initials, to parade with arms given by the government. With the arms given at the cost of public money, innocent civilians, innocent Tamil civilians are being done to death with impunity. With this, Madam Chair, I am very sorry to state that with a bleeding heart, I am compelled to participate in this debate. If I don't state these matters to be placed on record, I am afraid that I would be failing in my duty. We are with you. We are with you for the implementation of the law. If you are sincere and serious about it. What is Karana Group doing? Whose arms are they wielding? The government says, well, some members from the government ranks have been repeatedly asserting at press interviews as well as from public platforms that the LTT is roaming about with weapons. So as long as LTT is there with weapons, we can't disarm Karana Group. I am at a loss to understand. This is an irrational, illogical, and inexcusable explanation that is being trotted about, madam. You are fighting the LTT. LTT is the other side to the military conflict that is the offshoot of the political question of this country. That is a different proposition. That is a different scenario. That is a different story altogether. But in the government control areas in the east, when you allow an armed group or groups to roam about with weapons in the name of aiding the armed forces in upholding the rule of law, what is the meaning of it, Madam Chair? I am compelled to ask. Going by the same argument, can anybody tomorrow form his own group, armed group, an underworld group, and come forward to assist the armed forces so that they could be permitted to roam about, kill, maim, rape, rob, and abduct? I am forced to ask this question. When one talks with some sense, madam. One has to talk with logic. One has to talk with conviction. I find repeatedly there are assertions from the government ranks to the effect that Karana Group cannot be disarmed. Karana Group cannot be disarmed. I asked them, is it not against the law? Under what law Karana Group is being permitted to keep about 30 Jews in their camp in Tirukkovil, using the weapons given by the government? I am asking, madam. What the government has done in relation to the investigation pertaining to the cold-blooded murder of 18 aid workers attached to the French NGO in Mudur in August last year. What has the government done? Has one single suspect been arrested?
Order,
What?
please. Honourable Member, you have another 1 minute.
I thank you, madam. Madam, what has the government done? What's the purpose of keeping an investigative machinery in this country? People are being arrested for keeping a packet of ganja, or pickpocketing somebody in the bus, or abusing his or her neighbor, or taking away another man's wife with their own jewelry. They are being arrested. They are being paraded before courts, remanded. And if there are serious allegations, I have no reluctance to say that they would be brought under this bill, which would soon become a law. But at the same time, groups, armed groups, who have no qualms of conscience, no rules of behavior, no understanding of decency, knowing nothing about democracy, are being given an open license to do everything against the rule of law. I am asking. As a lawyer, I am asking. As a citizen of this country, I am asking. As one who believes in the good nature of men and women, I am forced to ask. Are you not cheating yourself? Is it not duplicity? What the hell are you doing when this man Karana is doing all these things? What the hell this government is doing when murder, robbery, rape, abduction are being perpetrated in the Northeast with impunity? Do I got to prove your credentials? No point in bringing this law with pious pontifications. No point. Whom are you trying to cheat? Are we puppets, or are we duds to remain silent spectators when all these great crimes are being perpetrated? I am asking you, as one who loves the law, who believes in the rule of law, who abides by the law, I am asking you. You have to prove, fight the LTT if you want, because I know LTT is also capable of fighting as long as there is fighting. And we can wait and see, provided the fighting ends during our lifetime. We can wait and see. We have seen it for the last 22 years. Not that I am for the fighting. I want the fighting to be stopped and the peace to prevail, so that through a political solution, I still believe in that. Though I find intransigence, inexcusable intransigence in relation to this obscene obsession that goes along with the commitment to a unitary state. Anyway, I will deal with that on another occasion. There are people in this country, there are members of this country who want the fighting to go on. They want to live on the blood of innocent Tamils, Sinhalese, Muslims and others, so that one day they can come to power. And I think sensible members would know whom I am meaning. They want this government to fight on. They want the next government to fight on, provided they are not part of it. They want the next government to fight on, so that this country will become bankrupt, bleeding to the maximum, and one day they can come to power. I would tell them, madam, using this opportunity,
Order, please.
if at all they are coming
Order, please.
I'll find them, madam, in a minute. If at all they are coming to power, they will be coming to power in a divided Sri Lanka. Only in the southern Sri Lanka, not in the Sri Lanka that is still intact territorially and constitutional. So, madam, I thank you for the opportunity that is afforded. I think sensible members, cultured members, all of us are supposed to be cultured and sensible, but anyway, I am compelled to appeal to sensible and cultured members to consider these matters, so that one day sanity would prevail and people would be in a position to reap the benefits of this type of laws. I thank you, madam. I thank you.